Thanks, Chris, and thanks, Beth, for making sure technically I don't falter. It's good to be back here, and I know this very successful conference, attendance and other things, content. I would be remiss if I did not mention a couple of announcements by the administration prior to the holidays. One of those had to do with net farm income, and we saw a 23.8% decrease from 2022 to 2023, 23.8% decrease. In addition, we will import in this fiscal year $200 billion in farm goods, fiscal year 2024, while exporting only $169.5 billion worth of farm goods, $30.5 billion deficit. Historically, ag products, U.S. ag products and exports have outpaced our imports, and we've been used in the general fighting a general larger deficit for the U.S. economy, but not this year. And I wanted to bring this up because it's generally symptoms of what we're facing, whether seasonal imports, as Chris mentioned, or what we've seen, of course, with ag labor, 21% increase in 2 years, and we'll talk more about that in a second. This morning, I will touch on several items impacting ag employers and an outlook for the short and the long term, specifically on ag labor reform. 118th Congress overview, we're in the second session. Ag labor reform in the House, in the Senate, touch on border legislation this passed the House. The Senate ag labor legislation, you've got some real experts here on ag labor regulations. I'm just going to touch on that, more of a general overview of why we're in this predicament. And then what's preventing major ag labor reform. This was important, I believe. We talked about it at the conference this past fall in Tifton. And what's next for the remainder of this election cycle pre-November. Okay, first congressional overview. Well, we have lots of challenges, not just in agriculture, but particularly for production agriculture. And this is coming at us from the administration and also the inability of Congress, House or Senate, to respond in any kind of way to, whether it's a bad regulation, as we've seen, regulations that we don't like, or whether it's something, a void that's not being taken care of. There are a couple of items that are hanging relative to the current appropriations process before we get too much into appropriations. 2022, this is an example, the Emergency Relief Program, that's an ag disaster program. Many of you remember we went through the WIP Plus when we had Hurricane Michael in the southeast. But ERP is the new acronym. The 2022 Emergency Disaster Program took a new format. We didn't have enough money going into to pay for the disaster. There were estimates like American Farm Bureau economists came up with approximately $20 billion in losses nationwide, California to the southeast. And the total amount of money was a little short, I think, of $5 billion in actual money that USDA received for 2022 disaster. So they came up with a new formula, which paid about 10% to production ag farms that historically produce a lot. They grow multiple commodities, particularly in the southeast, about 10%. So it didn't work. So that is something that we need Congress to cure. Not likely to happen. It's very frustrating for us. We're working on it. The second piece of this, we had an ag disaster in peach, blueberry, and some other commodities in 2023. We've got to get money in this next fiscal year 25, for these commodities, for the 23 crop. If it's not included in the 24 package, we'll have to get it in the 2025 package. We also saw, as you know, the 14% increase last year in the AWR, 7% for 24. U.S. Department of Labor regulations, proposed regulations that came out, and then seasonal imports that are impacting fruit and vegetables in the Southeast. We've been unable to fix this through the International Trade Commission with a blueberry case. We had some research done, but frankly, no recommendations. It's basically, this is how bad it is on squash and cucumbers, and I believe strawberries, too. Just a quick overview of the House. 92%, over 90%, roughly 92% of production agriculture is in Republican districts. 90% plus in Republican districts. We've got a new Speaker of the House who is trying to hold it together. But the margin keeps creeping in. We've had a couple of retirements at the end of the year, one Ohio, one California, one resignation. So the margin now is, depending on how you count it, 1 to 2 vote Republican majority in the House. So it's getting tighter. The problem has been from the beginning of the year, when we went through numerous speaker votes for then Speaker McCarthy, has been the small margin. So any group of 5 or more at that time could come in and shut the House down. Well, this past week again, a rule failed in the House that every member of the Republican majority supported, but it failed based on an appropriations deal that had been proposed right after we got back from the holidays. In the House, we have 2 members of the House Judiciary Committee, 2 leaders, Jim Jordan of Ohio, Jerry Nadler of New York City. Neither have any kind of major H-2A workers in their districts. There are a limited number of members of the House Judiciary Committee that have H-2A or significant agriculture. In the House Ag Committee, led by G.T. Thompson of Pennsylvania and David Scott, represents South Atlanta. Again, neither huge H-2A districts. In the Senate, we have Dick Durbin from Illinois, Lindsey Graham of South Carolina, ranking member, heading up Senate Judiciary. We have Senator Padilla of California, heading up the Immigration Subcommittee, which would have jurisdiction over any H-2A ag reform, immigration reform. Senator Cornyn of Texas is the ranking member of the committee and historically been supportive of our efforts on ag reform. Senate Ag Committee, Chairwoman Stabenow, and then John Bozeman of Arkansas. And Senator Bozeman told me recently that rice processors want to use H-2A, similar to cotton ginners in the Southeast. And there's significantly more interest in H-2A in Arkansas and in Rick Crawford's district, which is the Delta of Arkansas. I'm going to talk about Congressman Crawford in just a second. Okay. The battle we're in right now is fiscal year 2024, which started October 1 of 23. We've gotten top-line agreement, 1.7, roughly a little short of that, $1 trillion agreement on appropriation spending for the remainder of this fiscal year. 3% increase in defense spending, a little less than 1% decrease in non-defense spending. Yet to determine, what does Ag get? What does the Commerce Department get, State Department get, USAID within the State Department, DOJ? There's no definition as of yet. The clock is ticking on USDA and 2 other sectors of the U.S. economy. January 19th is cutoff. That's when we shut down for the first tranche of agencies, federal agencies. February 2nd is the second shutdown, but USDA is in that first. Fiscal year 2025, we're just starting it. Right now is when we typically would ask for projects, like for Georgia Fruit and Vegetable, Whitefly, working with the University of Georgia and Fort Valley State University College of Ag, is a project that's been around for several years. We've made tremendous progress in this area, but we have $8.25 million roughly that we received in the last fiscal year that's hanging. We're waiting on final approval of that to get for whitefly research, which is been important to vegetable growers as well as cotton growers in the Southeast. The other piece to this, in a new fiscal year 2025 that we're just starting, this is where we can make some tweaks to the NASS surveys, for example. It would be report language you're authorizing on an appropriations or funding bill. This is where we might attack some nuance within NASS that's not working for us, whether it's making judgment calls on the number of surveys that have been returned or responded to, whether it's questions that USDA might refuse to alter or to include in the package. It's lessening the survey. I know with ITC and blueberry, the surveys for blueberry growers were so lengthy that many did not fill them out. And so those are the kind of things we can do in an appropriations bill if they move forward. And this is about comparing farm bills, but it's farm policy, it's ag policy, production ag policy, and I'm going to come at this a little bit relative to general ag policy. These are farm bill numbers, and if we'll look at this, comparing members of Congress that were in the House in 2018 and voting on the 2018 Farm Bill, compared to today, who's in the second session of the 118th Congress, who's there today? We had 116 Democrats that voted for the 2018 Farm Bill, 2 voted no, 3 were voted present or did not vote. We had 92 members there today that have not voted on major ag policy initiatives, 92 members of the Democratic caucus. On the Republican side, 86 members are there today that voted yes in 2018 Farm Bill, 22 voted no, 1 present or did not vote. We have 114 Republicans. Now, please recall that most of production agriculture, most of what you're affiliated with is represented by Republicans. 114 have not voted before. Now, one of the frustrations of our base, particularly in the Southeast, of Republicans, more Republican than Democrat because most of our ag is there. For our base, the education process for members in the Republican caucus that have not had to make a decision on a farm bill or an ag labor reform bill, it's all new. So early on in 2023, the House Ag Committee and expanded rural caucus members in the House got together and started dividing up members of the Republican caucus, these 114 that have never had an opportunity to vote on ag policy, whether it's labor or farm bill or safety net or crop insurance, whatever the issue, to educate them. And they worked in teams and they spent a lot of time doing it. We're not sure this year if we'll have the opportunity on the farm bill yet. This is about money. There are very few legislative vehicles to attach ag labor reform or farm policy that moves forward. One of these that includes most of the policy issues for us has to do with the Farm Bill, 2023 Farm Bill. This just gives you an idea of what we're struggling with. When you say a 2023 Farm Bill, most people think of farm programs and research and extension reauthorization and those kind of things, crop insurance. But if you look at this, you can see in 2018, the Congressional Budget Office scored the 2018 Farm Bill 867 billion total cost. The projections for the 2023 Farm Bill with the same programs, this is nothing new. No new reference prices, no new seasonal import program, no infrastructure for land-grant universities, additional infrastructure for land-grant universities, et cetera, no new crop insurance products for specialty crops. That we're at $1.51 trillion. Now, even with a friendly House Budget Committee, no new money for the Farm Bill. No new money for the Farm Bill. So Chairman Thompson and his team of the House Ag Committee have to either go to other accounts that aren't agriculture, go to other committees and say, are there offsets to get us more money to do the things we want to do in agriculture? And that's really where we're lacking. As you can see, nutrition expands like crazy. Climate smart and conservation programs have boomed. Crop insurance has gone up a little bit, but to do the things that we want to do in specialty crop, on crop insurance, we need more money. And crop insurance risk management tools for specialty crops are, to be kind, varied. There are some areas they're okay, others they're commodities, they have no options or weak options, and all would agree they're all expensive. So to increase premium subsidies and to increase commodities that are covered in a really content-filled way, it's going to cost more money. Or the other option, than borrowing from other accounts, is to take from within the Farm Bill community, which the two pots of cash are really conservation or the climate smart money that was passed early in the Biden administration, or two, take it from nutrition, which that's very difficult. That immediately will divide the House and the Senate if you take too much reform, too much cash coming out of the nutrition account. Conservation, not as much, but still controversial. So this is where the debate is right now relative to the Farm Bill. Okay, in the House, we've struggled for any ag labor reform for decades. And part of it is that we continue with the Southeast and California or Western growers to cancel each other out. They come up with an agreement, Farm Labor Modernization Act, Farm Workforce Modernization Act is an example of that. They might can move it forward in the House, as they did, but we get to the Senate, there are problems with it, whether it's a private right of action, but Georgia Fruit and Vegetable had a host, and other Southeastern groups had a host of other issues that they wanted changed before the bill moved forward. So Southeast versus the West. H.R. 2, the border bill, passed the House, never to be considered by the Senate. Never to be considered by the Senate. In the Senate, we have, well, I'll get this in a second, but in the House, we have, and this is something I want to talk about toward the end as far as a long-term piece, this House Ag Committee, Ag Labor, Ag Workforce Task Force. Chairman Thompson created this with Rick Crawford as the Republican chair, Congressman Davis, Democrat of North Carolina, as the Democratic co-chair. The group has an interim report. It's on the, if you go to house.gov, House Ag Committee, it's just plug in Ag Labor and it'll pop up. It's an interim report. We're going to see the final report in the next 30 days or so, according to Chairman Thompson. And this report is meant to be a reform template, a tool for the House Judiciary and the House to use in moving ag labor reform forward. Now, a lot of skepticism that we'll see ag labor reform in 2024. But this document is a living document and will go forward. This is something, because we won't see that huge a changeover in the House Ag Committee or a large changeover in the House Judiciary Committee. And that's where this kind of legislation is going to bubble up, particularly with judiciary. This could be a really good template for us. So for a long-term strategy for the Southeast, we want to make sure that document says the things that we want ag labor to look like, whether it's including processors, having a realistic approach to the AWR as far as increases. That document's important. And I wish you would go and take a look at it very soon. Contact your congressman or senator later on, but congressman, if you have a problem with something or something's left out, probably more of the latter versus things in there being controversial. But that is really important. And we have numerous members from the Southeast that are on that committee, but it doesn't matter if they're on it. They certainly can get the Republicans to Rick Crawford, Democrats to Congressman Davis of North Carolina before they close that out within the next 30 days. In the Senate, okay, No action on the House's border bill. They have a task force of working on the border issue, which would go into the supplemental appropriations bill, which has the Ukraine and the Israel funding in theory. That working group is led by Senator Murphy of Connecticut, Senator Bennett of Colorado, who led it in the last year, is also involved in it. Senator Cornyn and Senator Lankford of Oklahoma are also in it. We've gotten significant pushback in trying to include any H-2A, even the limited Ossoff-Tillis freeze on AWR, and stand down and let us get some air before we see another increase. Not likely to be included in that package. Too controversial, brings in too many other issues, and we have some members of this task force in the Senate that are saying we're not going to do anything on the AWR unless we do the whole Farm Workforce Modernization Act. And at that point, we have multiple farm groups that will kick in and say, well, we can't support that. I know that and Margaret and others are going to talk about the regulatory issues at stake for ag employers, but I wanted to make a couple of comments in this area about why this is happening politically, like the ag labor USDOL proposals are happening as we see them now. If you'll look back to the Obama administration, once the Obama administration recognized that they were not going to move an agenda through Congress, they set up 80 to 90 what I call cells of career employees, some political, but mostly career, to work on various proposed regulations. And the White House would filter through those and say, well, we want to do this, we don't want to do that. I don't think this is as formal a process as we saw during the Obama administration, but I think President Biden's team clearly has seen they're not going to be able to move their agenda through this Congress in a Republican House, particularly at the state we're in now. So they have opted for the approach that we're witnessing today and we're victims of today, particularly with DOL. And I raise that because it's not done yet. We're likely to see more proposals come out of the Department of Labor, and we want to be very watchful of this. And without a Congress that's structured today to address it, we are at risk. And we've seen that with what's happened with the AWR, and we've seen that happened with other proposed regulations that are impactful. All right, why are we in this mess? Part of the problem is we've got too many ag labor reform organizations. Some groups that all they work on, other groups that this is one piece of their policy agenda, and generally would be all for some of the same things, but different priorities within the ag labor policy portfolio. And what we're finding when we get into a situation like we've had this past year with a 14% increase on the AWR in the Southeast, at least Georgia, Alabama, South Carolina, Georgia, Florida, South Carolina, what we are facing are groups with different priorities. If packages that are being developed to resolve these problems don't include their issue or include their issue, don't address it the way they want it addressed, they can veto it. Now, with all these groups involved, you get a half a dozen to a dozen organizations. That's satisfying a lot of people. And one of the easiest lines for Congress to use is, well, come back when you're all together. Come back when you've all worked out this specific area of ag labor reform. So we've got a lot of organizations. Regional differences, I mentioned earlier, California versus the Southeast. This has to get cured. Southwest U.S. agriculture, production ag, Midwest production ag, and California or Western growers all are very united in different aspects of production agriculture policy. You don't see that in the Southeast or the Northeast. The Northeast is not irrelevant in production ag, but not as dominant, not as much representation. And many of the representatives on the House Ag Committee, for example, or the Senate Ag Committee are more focused on specific commodities or organic agriculture or vertical agriculture or whatever the specific item is. But on traditional production agriculture, what you do for a living, not so much organization and teamwork from the Southeast. That's hurt us. Partisan division, we've talked a lot about. The bipartisan caucuses in the House, the bipartisan think tanks in Washington are having, unfortunately, less impact than we've seen in the past, less influence. Saxby Chambliss co-chairs one of the bipartisan think tanks in Washington with Heidi Heitkamp, who's a former Democratic senator from North Dakota. But a lot of ideas, but not having huge impact on the kind of issues that are critical to our team. Controversial legislation. I think if you look back when the only solution to legal services and some of the problems I know that our ag employers were having in the Southeast was to zero it out. So those members that wanted to address it thought the only solution was to kill legal services. Well, it was not going to happen. Instead of reducing it, drawing up tighter parameters or boundaries for the agency, it was zero it out. Well, it doesn't go anywhere. If it can get out of the House today, which it might get past the House today to zero it out, it's dead in the water as far as the Senate or a signature from the President. Then election cycles. Control of Congress is in play. What was a 5-vote margin when we had lots of conflict in the Republican caucus early in the 2023 has now been reduced. We've had 3 members that resigned or retired at the end of 2023. So at this point, those seats have not been filled, so that margin's tighter. So we could find ourselves in a much more complicated situation after this appropriations deal, once it moves forward, hopefully this next week, with leadership than we saw in the first quarter of 2023. After July 30th, if we have not moved a farm bill or ag labor reform, after July 30th, we're done. August, Congress is out for their August break. They'll come back after Labor Day. We're dealing with appropriation bills. Frankly, hopefully, I think it would be a dream if we got through with the fiscal year 2025 on time. Not likely. So we'll be in the middle of a continuing resolution to fund the government for FY 2025. So nothing will happen in October. Congress goes home and won't come back to Washington till after the November election. So as you can see, the next 2 quarters are critically important. If we don't see some type of reform for labor between now and July 30th, June 30th, July 30th, it won't happen this year. Okay, short term, I thought we had an opportunity with the border bill in the Senate. The margin over there, as you know, is 51-49. There are 3 independents that vote with Democrats. Without us making it into the border bill, whether it's a narrow AWR fix or Farm Workforce Modernization Act or some other ag labor reform, there's no short-term legislative vehicle to fix this. 2024 elections will determine direction of ag employer regulations. That's my view. If the president's reelected, we're going to have a tough time with DOL, could have a tough time with DOL policy without a Congress that's able to react to things or to pass some type of comprehensive ag labor reform. The USDA NASS piece is complicated. We had a meeting that Congressman Bishop, who's the ranking member of Ag Appropriations, longtime appropriations member, his lead ag policy person is a career NASS employee who has been on loan to his office to work on issues like this. And we're yet to come to any kind of specific conclusion on how to cure the NASS surveys or if there is something there that would help us. So this is a piece, if we're going to do anything on NASS, we might could steer that, not outright direct it with authorization legislation, but steer it through guidelines that we could put in an appropriations bill for fiscal year 2025. There's an opportunity for that to have a little influence on NAS between now and the end of March when they start putting together the fiscal year 2025 appropriations bill. Congress, the House could flip in this next election cycle. As you know, it's tight. If we still have a thin margin with either party, it could be problematic. The same could go with the Senate, although the Republicans appear to have a little edge in the Senate with the number of Democratic seats that are up.
Okay, guys. Thank you, Bob. Appreciate it. Yes, sir. Our next speaker is Michael Marsh with the National Council of Ag Employers. And unfortunately, Michael went to the airport in Chicago, I believe, yesterday or the day before, and they told him they weren't going to bring him here because of the weather and the storms up there. So Michael is kind enough to join us via Zoom. Again, he's the CEO of the National Council of Ag Employers. And most importantly, NCAA is a good friend of GFVGA. We work closely on a lot of items. Michael is an invaluable resource that has forgotten more about immigration policy than some of us will ever learn, but he's going to tell you about some of the actions that they are working on to help address AWARE and the other concerns we have with H-2A. So, okay, Michael, you've got a room of about 4,000 folks.
Oh, perfect.
No, you've got a good cross section of growers from around the Southeast. You're amongst friends, and they're looking for some good news from you. So
awesome.
With that, I'll turn it over.
I really wish I was there in person, but unfortunately, as Chris indicated, they wouldn't fly me down there. So I'll go ahead and start with my slides. Can you guys see those okay?
Yes? We're not seeing those yet, Michael.
Okay. Let me share my screen. Try to share my screen. It says host disabled participant screen sharing.
I can take care of that.
Beth is working on that.
Okay.
I believe those are Beth's hobbies.
Okay, now let's see if it works now.
Oh. Yes, sir. We'll do that.
Okay.
There we go, Michael.
Cool. So let's go ahead and get this rolling.
All right, we are seeing the PowerPoint. So let's get that going. PowerPoint mode.
Yep. How's that?
Yes.
Perfect.
Okay, perfect. Well, thank you once again for the invitation to visit with you. And again, as I mentioned, I sure wish I was there. It's about 40 degrees here in Arlington, Virginia. I can look out my kitchen window and actually see the Capitol across the way. Well, I always like to start these conversations by taking a look at the numbers. According to the 2017 Census of Agriculture in the United States at that time, we had about 2.4 million hired agricultural workers. And at that time, we had about 200,000 H-2As, which means essentially that we had about 2.2 million domestic farm workers in the United States. And that domestic farm worker number still dominates our workforce, believe it or not, because I know in many parts of the country, it's hard to find anybody that'll even show up or apply for the job if you've got one. But one of the other things we know about that 2.2 million ag workers is that according to the National Ag Workers Survey done by the Department of Labor, about 50% of those domestic workers are here in unauthorized status, which means that they're here illegally. So that's one of the challenges you have from a policy perspective as to what do you do with all those that 1.1 million agricultural workers who are domestic workers but here in unauthorized status but show up every day to go to work. Well, Philip Martin, a professor at the University of California, Davis, actually has done some really a good deep dive into numbers in the state of California, looking at unemployment insurance filings for employers. in California, and he found in 2015 that the total number of ag workers in the state of California, based on those unemployment insurance filings, was 847,000. He redid the survey again in 2016 and found that as a result of the drought lifting a little bit out in California, the total number of workers with at least one job in agriculture during the year in 2016 was 989,000. And that's why it's so important that we get these numbers right and we really kind of think about it from a holistic perspective as we talk about policy. Now, in the 115th Congress, a friend of mine, Bob Goodlatte, a Republican out of Virginia, who was able to work with very closely on a number of ag-related bills, introduced legislation that would have eliminated the H-2A program and replaced it with an H-2C program. But unfortunately, with regard to Congressman Goodlatte's bill, he was under the impression we only had 800,000 agricultural workers in the United States. And if that bill had actually gone on and become law, we would have never been able to fill that shortage because it also included mandatory verify for the rest of the country. And of course, at that point, then everybody's competing for everybody else just to get their petitions filed. It'd be almost like an H-2B situation with regard to H-2A. So fortunately, that did not occur. But one of the things that I also like looking at the numbers is the total H-2A positions that are certified by fiscal year. And media always gets this wrong because they see that 378,000 number and they think that's the number of visas. But of course, that's incorrect because we do have some of those workers that have jobs that are certified that can come in on visas but do more than one job during the year. So we had 311,000 visas issued in the last fiscal year. But here's where we get into the weeds a little bit again on some of the numbers. That was an increase year over year in fiscal year 2022 versus fiscal year 2021 was a 17% increase. But that really changed in 23 versus 22, where we only had 7,000 additional jobs certified, or 1.85% increase in 2023 over 22. And I think that part of that, even though I don't have any empirical evidence for this, but it's got to be due to the adverse effect wage rate just driving employers crazy with the elevated wage rates that you're being forced to pay. But one of the other things that I think helps us a little bit in some of the litigation, and Margaret probably shared with you, is that the application numbers were up 10.5% in fiscal year 2023. Now, you might recall with those disaggregated wages under the new adverse effect wage rate regulation started in July. Okay, at the beginning of the last quarter. And in the last quarter, even though the Department of Labor originally had indicated within their rulemaking that we were only going to see a 2% increase with regard to the number of petitions that were filed, we saw an 8.8% increase in the number of petitions that were filed for disaggregated wage positions. So clearly, they were not correct with their assumption, and that should help us and bolster our legal arguments in court. But why do you even have an adverse effect wage rate? Because, of course, the requirement to pay the higher of wage rate is to avoid any adverse effect on the domestic workforce due to the employment of the H-2As. Domestic workforce? What are we even talking about here? Well, underneath the H-2A program, as you're well aware, employers have to pay the higher of the state or the federal minimum wage, a collectively bargained rate. Unfortunately, we don't have a lot of union activity or unions certified in agriculture at this time. They're sure trying, though. We're going to talk about that in a moment. Or a prevailing wage or the adverse effect wage rate. And most of us, unfortunately, are stuck with that adverse effect wage rate. But 337 in March of 2020, March 13th of 2020, President Trump announced a national emergency due to the global pandemic. And at that time, there was an effort on behalf of many of the conservative members in the House of Representatives to eliminate the H-2A program with the notion that with all of these domestic workers unemployed, they couldn't wait to come out to the farm to do the job. I couldn't get this data from the Department of Labor because they only accumulate this data at the end of the year. But I asked each of the state workforce agencies, I asked all 50 of them, to give me their data from the period of March 1st of 2020 until May 15th of 2020, how many domestic workers actually applied for the 97,691 jobs that were available. And the answer was, after we got responses back from 28 other states, we got California, Washington, Oregon, Georgia, Florida, New York, Michigan, Texas, most of the bigger states. The total number of folks that applied for the jobs were 337 for 97,691 jobs. And we don't know, at the end of the day, how many of those 337 folks actually accepted the position once it was offered to them, how many of them made it past noon on the first day, because farm work is hard work, or how many claimed that they got hurt on that very first day and decided instead to go on workers' comp. Well, the state of Washington has tried to place additional domestic workers into some of these jobs because the state of Washington is one of the big players, along with Georgia, of course, with regard to H-2As coming into the state. They typically get about 36,000 or so H-2As coming into Georgia. So one of the unions up there, a union called Familia Unidas, got together with their state workforce agency to try to place domestic workers into these H-2A jobs. And in fiscal year 2021, they had about 36,000 of these H-2A jobs available in Washington state. Working with the union and the state workforce agency, they got exactly no applicants, zero. None of them. No one applied for those H-2A jobs. And those H-2A jobs in Washington state this year will pay $19.25 an hour. And you couldn't get anybody to even apply for the job. Well, the next year, in fiscal year 2022, they did a little better because they got 11 people that applied for the jobs because they tried it again. Well, clearly, how can you have an adverse effect on somebody who won't even apply for the job? So what is the problem? In my experience, working with the National Ag Statistics Service, they do a really good job with regard to surveys. But the problem exists when the Department of Labor misuses it. They misuse it as a wage discovery mechanism. And of course, it's disconnected from actual wages that are paid on the farm. And the H-2A wages are included within the survey to some extent instead of excluding them. Piece rates, overtime, if you're one of those jurisdictions that is forced overtime on your farm workers, bonuses, those are all included, and then all those wages are then averaged. Sonny Perdue, in a very good letter that he wrote back in 2019, actually after he was getting a lot of heat for the Farm Labor Survey, explained to folks, this was never intended to be a wage discovery mechanism used in the temporary ag worker program, but unfortunately the Department of Labor continues to misuse it. And that is where we are today. Secretary Perdue actually tried to stop that in the fall of 2020 by suspending the Farm Labor Survey. And then, of course, DOL had to come up with a new rule, but UFW successfully enjoined the action by both the Secretary Perdue as well as the Department of Labor. Well, as I mentioned, AWERs generated by the Farm Labor Survey are disconnected from actual ag labor markets anywhere on the planet. These wages don't exist anywhere except in the mind, I guess, of the Department of Labor Secretary. As we know, the federal minimum wage is $7.25. The average 2022 Farm Labor Survey wage was $16.62 an hour, and in 2023, the AWER average is $17.55. From $14.53 in the Delta states to $19.75 in California, that puts it at 2.42 times the federal minimum wage. This is ridiculous, and it's driving farmers out of business, and it's not okay. And to make it even more miserable, now we've got to change our wage rates twice a year instead of just once a year because now we've got disaggregated wages. And when you look at these wages for somebody, who would have ever imagined that sometimes you drive a truck on a farm, sometimes you do construction work on a farm. The Department of Labor, and this actually started during the Trump administration, sadly to tell you, decided to disaggregate some of those wages because, of course, you're having a negative impact on the employment of truck drivers, right, in the United States, if you're using truck drivers on the farm to move the crop from the field into the packing shed. And of course, one of those other challenges you've got with regard to that part of the regulation is that if you have a truck driver and you're paying him a truck driver wage and he rejoins a cohort of workers back in the field pulling weeds or harvesting crop or doing whatever, those domestic workers are now going to be in corresponding employment with that truck driver, and you've got to pay them the truck driver wage for the entirety of the contract, even though they never stepped foot in the truck. It makes no sense at all. No sense at all. Well, and this is one of the challenges we as in American agriculture have. is that our adverse effect wage rate is putting us at a considerable disadvantage to our foreign competition. Today, more than 60% of the fresh fruit that we consume in the United States and more than 40% now of the fresh vegetables that we consume in the U.S. are coming from our foreign competition, primarily Mexico and Canada. And when we look at the wage rates, Mexico at about $1.50 an hour, that's 300 pesos a day, converted for about 11-hour day, that's about $1.50 an hour. But in California, you'd be paying $19.75. In Washington State, $19.25 is going to be your AWER versus $12.56 an hour in British Columbia. Why would anybody want to produce food in the United States? $10.50 in Saskatchewan versus North Dakota at $18.32. Can you imagine that? Rural North Dakota, a town of 150 people, and now you have to pay $18.32 versus going across just across the border to Saskatchewan. Michigan, $18.50, Ontario, $11.74, and of course, Florida versus Mexico as well. This is killing domestic agricultural production, and our production is fleeing the United States to some place where they can actually make a dollar now and again. Well, a legislative update very briefly, because I'm sure Bob touched on all this very well. But I really don't see a path forward for a big ag bill. Speaker Johnson, I think he's figured out he's got a tiger by the tail. And of course, we've got Jim Jordan, Republican from Ohio, is the chairman of the Judiciary Committee, where an immigration bill would have to go through. We tried a Congressional Review Act effort with the members of Congress, and it was very disappointing because this would have been with regard to the rolling back the adverse effect wage rate regulation. But unfortunately, we had a number of Republicans that didn't support us, Mr. Schmidt and Mr. Hawley from Missouri, as well as J.D. Vance out of Ohio, again, with this idea that we've got all these domestic workers that just can't wait to get out to the farm. Your Senator, John Ossoff, a Democrat out of Georgia, and Tom Tillis, Republican out of North Carolina, introduced legislation that would have rolled this back for 1 year to the wage rates that were effective as of December 31st, 2022, and that has not been scheduled for a hearing in the Senate Judiciary Committee. The Farm Workforce Modernization Act was reintroduced by Zoe Lofgren, from a Democrat from California, as well as Dan Newhouse, a Republican from Washington State. But again, I don't see that that's going to get much movement. The Dignity Act by Maria Salazar, Republican out of Florida, as well as Veronica Escobar, a Democrat out of Texas, was introduced. And that's much more comprehensive bill, and it would also include taking care of DACA and some other things. So that's out there. But again, I don't see that moving. The Hire Act by Tony Gonzalez, Republican out of Texas, was introduced. The bill's only 3 pages long. And essentially what that bill would do would be extend that visa period for a period of 3 years. So I really don't see that advancing either, unfortunately. The Ag Labor Task Force, put together by House Ag Committee Secretary G.T. Thompson, Republican out of Pennsylvania, they came out with a proposal to reform H-2A. Actually, we've got some draft legislation at the National Council that my executive committee is probably going to give me authority on Monday to go ahead and shop around to see if we can get an author or two for it, which would eliminate the adverse effect wage rate, absent us showing that there is an adverse effect on the domestic workforce. Completely get rid of it. Get rid of the disaggregated wages, because you wouldn't have a need for those either. In addition to that, it would also expand this so that folks that are doing dairy or poultry or hogs could actually participate within the program as well. I want to give you a heads up because there's overtime legislation that's being proposed at the federal level by Alex Padilla, a Democrat senator from the state of California, and Raul Grijalva, a Democrat House member of the House from Arizona. This would eliminate the exemption from the National Labor Relations Act for ag overtime. Also, as I think Bob probably shared with you, there are some efforts within some of the appropriations bills to actually advance some of the AWER changes. One would eliminate the disaggregated wages, but you'd still have to keep in that the use of the FLS. Otherwise, the Department of Labor would have nothing under that appropriations bill to go ahead and hang their hat on with regard to wage calculation. And there has been some legislation to freeze the wages as of December 31st, 2022. But again, I think that those bills will have some trouble advancing as well within this Congress. But one of the things that's fascinating is you had some of these jurisdictions that thought, and this has been touted by UFW, United Farm Workers, trying to get these in place, but let's just get rid of overtime within the state because, of course, the ag workers will make so much more money. Well, actually, we've got research now that shows exactly the opposite. It hammers the farm workers in those jurisdictions where you've actually placed overtime into statute. And you think about it, if you're at 60 hours, you're making $14.68 an hour, you're going to be taking home on a weekly basis almost $900. When you reduce that to 40 hours, however, the farm worker takes home less than $600. It has been interesting to kind of watch as this research has rolled out from the University of California, because UFW has had to pick up a talking point that at least the farm workers can now spend more time with their family. And of course, UFW ignores the fact that now the family has to go on food stamps, or they have to go on Medicaid for their health insurance, or they have to move to another location because where they're living, their home where they were living, is just too expensive for them to afford now. But that's United Farm Workers for you, and they are into all kinds of mischief right now. As Ann Margaret probably shared with you, we are involved in a good deal of litigation right now. The NCE versus the Department of Labor. This is on the program rule. The rulemaking actually began for this regulation, as I mentioned previously, during the Trump administration, became final during the Biden administration. And where this really hurts is with regard to eliminating the statistical integrity for a state workforce agency to do prevailing wage surveys. Now, this hasn't really worked out, I think, the way the United Farm Workers had hoped it was going to work out. But nonetheless, that lack of statistical integrity in those prevailing wage surveys could make it more likely that other jurisdictions, other state workforce agencies could perhaps be subject to these prevailing wage surveys. Surety bonds jumped, the price for those jumped way up underneath this new program rule. And that's one of the reasons we're challenged as well, because it's amazing because you've got some of the states now where more than 50% of the workers being provided are coming through a farm labor contractor. But of course, the farm labor contractor takes the cost of that surety bond and passes it along to the grower, which simply increases the cost to the grower. So that's not a win. We are also suing the Department of Labor on their adverse effect wage rates. Is there an adverse effect? We don't think so. I mentioned earlier that Secretary Perdue indicated quite clearly that this is a misuse of the Farm Labor Survey to drive these wage rates. And I'm 100% with the former secretary on that. They're extraordinarily inflationary, as we see every year when these come out. And as I mentioned, the disaggregated wages are now there. I've raised the cohort issue. And the costs and petitions associated with this is just a mess. We got word finally from the magistrate down in the district court in Florida, and he is not recommending that we get a preliminary injunction. He's not recommending the district court judge is going to make a determination that we not be able to enjoin this. But at the same time, he did suggest that our litigation should move forward, as he denied the Department of Justice's request to dismiss the action. And NCE also now, and along with the Georgia Fruit and Vegetable Growers Association, and have now filed petitions as well with the Assistant Acting Secretary, Julie Sue, to provide us some justification for why you're even having an AWR, because as we know, there's nobody that's being adversely affected due to the employment of H-2As in the United States, and she's got to come up with some justification as to what she's doing. Another case that we're probably going to get involved with as an amicus, Ann Margaret's firm is very deeply involved in this case up in New York State with regard to unionization of your workers with card check. New York State, like California now, has followed suit. They had this great idea that, you can get rid of that secret ballot election. Yeah, we'll just unionize them by having them sign a card. But what we're seeing over and over and over again with this case up in New York State are allegations of union misbehavior. In Matamoros, we had H-2A workers that were crossing in from Mexico. They were going to get their visa the next day. They got a call on their WhatsApp, on their telephone, saying there's a mandatory meeting. You have to leave the bunks, and you have to come out to another location. And when they did, they were assuming, of course, it was going to be the owner of the orchard, the apple orchard up in New York State, the supervisor given some information about getting their visas the next day. And instead, it was United Farm Worker organizers saying that if you don't sign this card, you will not get your visa tomorrow. And of course, when one of the workers objected, and we've got this on video, one of the workers, it's nice that he had a cell phone and videoed it, but when he refused, one of the UFW organizers explained to him, "You better be careful because I'm from Sinaloa," as a direct threat to the worker for not signing the card. Well, Jamaican workers similarly had an experience as they're getting ready to go back to Kingston. They'd been up picking apples for the season up in New York State, and UFW, same thing. Had them pull out of the bunks, had to go to a different location, and told them if they would sign those union cards, the next year when they come back, they would qualify for a green card as a legal permanent resident. Well, of course, that's not true. It's UFW misleading the workers. Well, and here I think one of the really good issues I think that Margaret's firm has raised within this litigation is the federal regulation versus the state, because the state has no ability to regulate immigration. That belongs with the federal government. I think Governor Abbott's going to find that out down in Texas with some of the rules that he's tried to put in place down in Texas. But also here that was really good, I think, is a stipulated agreement was entered into with the Attorney General. And as I mentioned, NCA is likely going to file an amicus brief in support of the New York State vegetable growers up there as well. Well, here's a case that you probably haven't seen, but it's Torres Hernandez and a group of folks versus Julie Sue. And in this case, the acting secretary actually had to defend herself against having a regulation that would expand even further the adverse effect wage rate, because they lost in the district court. That's why it's being appealed to the Ninth Circuit. But this would force the use of a piece rate formula instead of the A where in all crops, even though all crops were not found to have piece rates in surveys, which would, of course, drive up labor costs. It's the Ninth Circuit, so you got to kind of keep an eye on it because they come up with some really crazy ideas. But nonetheless, that's another piece of litigation we're keeping an eye on at NCE. Here's some other stuff. The Department of State originally came out with an effort to significantly increase their cost on the visa fees. Ended up with $15. USCIS has an effort, also a regulatory effort, to increase fees by more than 237% for the USCIS fees. That final rule has now gone over to the Office of Information and Regulatory Affairs at the White House, and I've asked for a meeting with the White House to talk about this, to once again press the issue that what they were asking for was ridiculous and their math was wrong. Early indications that I've received so far from some of the folks that have seen this final rule is that NCAE's comments had a pretty good impact on reducing what that's going to be. We're probably not going to get rid of all of it, but in some cases it's going to be much less than 237% increase. I would watch in 2024 for that OSHA heat rule. We've had 2 advance notices of proposed rulemaking on that, so I'm going to watch for that coming out of there as well. USDA finally closed their grant agreement for $65 million. Originally, they were going to have United Farm Workers provide technical assistance, and they did get some money out of USDA for providing some guidance to USDA as to what this grant program should look like. So, of course, with UFW involved, it's not as good a deal for the farmers and ranchers who may want to participate in the program, but that's there. OSHA published has a walk-around rule that's with the notice of proposed rulemaking. We filed comments on that, and this would be a rule that would allow a United Farm Workers union member to accompany an OSHA inspector when they come on your place to check things out. And I kind of had to ask the question: Are you really afraid you're going to lose the OSHA inspector if you don't have UFW with them? This essentially allows, once again, the union to have access to your place and to your workers. This week, the Department of Labor also published their independent contractor rule, and you might recall that when California did something similar, it pretty much shut down the ports of Los Angeles and Long Beach because all the truck drivers that had been independent businessmen driving cargo to and from the port, all of a sudden they were told by the state of California, "You're no longer an independent businessman; you're an employee." Well, they didn't like that, and they struck. So they weren't going to. That didn't sit well with them. But watch out, because this rule is going to be coming to your place. Well, a couple things and this other stuff. The Department of Labor published a notice of proposed rulemaking on worker protections. And as I mentioned when I visited with folks down at the Georgia Fruit and Vegetable Ag Labor Forum, it's pretty much as if the Department of Labor heard what the Supreme Court said in June of 2021 in a case called Cedar Point Nursery versus Hasid, and they heard that, but instead they said, we're going to give the one finger salute, and you pick out which finger to the Supreme Court, because the Supreme Court surely does not understand what the United States Constitution has to say. So this rule would actually go ahead and allow unions to have access to your place, directly contrary to what the Supreme Court just said in 2021. Have access to your place, have access to your workers. But it goes even further than that. This regulation is so pejorative, or this proposed rulemaking was so pejorative. I actually went to the Department of Labor and sat down with the Wage and Hour Administrator and told her that this never should have come out of her shop. It essentially paints all employers as bad actors. And unfortunately, it carried through into the tenor of this proposed rulemaking, but it should never come out of their shop. This is going to draw, if it comes out the way that it's been proposed, this will draw litigation as well. The Department of Homeland Security similarly had a notice of proposed rulemaking on worker protections. A lot of this in the DHS rule, it didn't have the pejorative tenor that we did see in the Department of Labor rule, but in some of the DHS rule actually made sense. So it was kind of a mixed bag. Some of it was good, some of it was bad. We opposed the bad, we supported the good, and that was there. And of course, now we're looking at, are we going to have a government shutdown again? I hope not. The appropriations bills for the Department of Agriculture is supposed to, the Department of Agriculture is supposed to shut down after January 19th. And the Department of Labor, who's doing your Office of Foreign Labor certifications, they're scheduled to shut down if we don't get a deal by the 2nd of February. So watch out for that. Again, I mentioned Speaker Johnson realizes he's got a tiger by the tail. I'm going to jump back really quickly to this Cedar Point versus Hasid case, because this is really important for this Department of Labor notice of proposed rulemaking on worker protections. Because the Fifth Amendment states in part that nor shall private property be taken for public use without just compensation. And this was the issue that was before the Supreme Court in the Cedar Point versus Hasid case, because the ALRB out in California, their National Labor Relations Board, but it's for California only, of course, had this regulation in place that gave the unions access on a regular basis to your place, whether you wanted them or not. You didn't have an ability to tell them, no, you can't come on the place. No, I have Food Safety Modernization Act protocols that prevent me from bringing you on the place. You are not supposed to come on my place. And so the ALRB, with their regulation, said, oh, yeah, you can, union, you can go on the place. But the Supreme Court found differently in a 6-3 decision. And as I mentioned, this notice proposed rulemaking would create an access regulation at the federal level that, as Chief Justice John Roberts explained in the Cedar Point case, appropriates a right to invade the grower's property and therefore constitutes a per se physical taking. Rather than restraining the grower's use of their own property, the regulation appropriates for the enjoyment of third parties, here union organizers, the owner's right to exclude him from the property. See what I mean about giving the one finger salute to the Supreme Court? The Chief Justice continued that because the regulation appropriates a right to physically invade the grower's property to literally take access, just like the Department of Labor's new rule, take access, it constitutes a per se physical taking under the court's precedents. And the court also declined to adopt the theory that the access regulation merely regulates and does not appropriate the grower's right to exclude. This was a really good decision in our favor. The right to exclude is not an empty formality that can be modified at the government's pleasure. And I was happy to share that with the acting secretary in our comments. And I also went on to say, sadly, through what can only be generously attributed to thinking that is convoluted, someone asserted that these proposed regulations will not be preempted by the National Labor Relations Act. The National Labor Relations Act from 1938 actually provides an exemption for overtime and unionization for agriculture. And so I had to ask, are you serious? You think you can do this by regulation? I don't think so. But then I went on to say, but at least that thinking is consistent with the delirium which must exist in the belief that the Supreme Court was ignorant of the Constitution of the United States in deciding Cedar Point. As you can tell, we were a little upset with this proposed regulation. Well, this past spring, I had an opportunity to speak to the Agriculture and Applied Economics Association here in Washington, D.C. And they had 2,200 economists that had registered for the event. And they asked me to be their luncheon speaker and asked me to speak about ag labor. But as we were wrapping up, they also indicated they would like me to tell them what I would like to see coming from some of the research institutes around the country with regard to ag labor. One, I asked them, please help us prove from an economic perspective that there is no adverse effect. We have some researchers at the University of North Carolina North Carolina State University, that are looking into this right now. And I've got some other efforts taking place in Michigan State as well as out at the University of California. What are the impact of wage rates, such as we got with the Farm Labor Survey, that are disconnected from the market on U.S. production and national security? I'm going to argue from the production side, we see it leaving. It's going to Canada or Mexico, anywhere that it can avoid that additional cost. But what does that do for our national security? I put that out there. What are the impacts to productivity on your farm or your ranch and worker safety if you have a union come on the place? Because if you're talking to your banker and you've got a union on your place and your productivity is going to decline 30 to 40%, from your workforce because of the union being there, and your workers' comp claims are going to jump by 25%, that's information that might be good for you to have in your back pocket when you're having a conversation with a banker. And what are the impacts to farm worker take-home pay from the ag overtime exemption elimination? We have had that one study out of the University of California at Berkeley that looks at the National Ag Workers Survey data specific to California, and exactly what I mentioned previously occurred. Farm worker pay dropped after overtime was implemented there. Well, and to close with the late Henry Kissinger, does anyone have any questions for my answers?
Thanks, Michael. We're going to turn the lights up here back in the room and see if anybody has any questions. Any questions for Michael? Michael, you can hear me still okay?
Yes, I can.
Okay. Any questions? Michael, the question is, how unified are all the members and employers of your organization?
I think that they're unified around a couple of things. One is that we've got to get something fixed. We've got to get something changed. And we have representation from the West Coast to the East Coast to the Southeast to Texas to the Midwest. That something's got to change. Something's got to give. I think we're unified in that. As Bob mentioned, when we saw what came out of the Senate with regard to Farm Workforce Modernization Act, that created some consternation within our organization because, of course, we supported moving FWMA through the process with the understanding that in the Senate, we were going to get some better language for employers. Actually, Mike Crapo, a Republican U.S. Senator from the state of Idaho, was working with Mr. Bennett, or at least we thought he was working with Mr. Bennett. Mr. Bennett, unfortunately, did not take any of the suggestions that we provided to Mr. Crapo in what was supposed to be a negotiation between Mr. Bennett and Mr. Crapo, and he ends up with a bill, Mr. Bennett did, that couldn't get any Republican support, and of course he tried to tack it on to an omnibus that was moving out of the Congress last December, and of course that wasn't going to go anywhere. But I think from my members' perspective, something's got to get fixed, because otherwise we're not going to have food production in the United States. And the folks I represent are probably just like yours, Chris, that they're those generational legacy farmers and ranchers who want to not be the last generation on the farm or the ranch.
You're right. That describes who's with us here in the room. I've got one for you, Michael. It's always hard. We have constant updates and regulation and rule changes that impact the program. But that seems to have accelerated under the current administration, and it seems to have accelerated where those agencies are going further outside the bounds of which they're authorized to operate by Congress. Do you just maybe kind of a yes/no question? Have you seen that acceleration, and do you think these agencies are indeed acting beyond the scope of their authority?
Absolutely.
Absolutely. Okay. Any other questions for Michael?
What do you see the likelihood of losing the exemption for overtime pay to ag workers?
Michael, the question is, do you losing the overtime exemption for ag workers? Do you see that spreading and going to other areas? What's the likelihood of that?
Yes, I do. I think that it's fairly likely. However, the research that we got out at UC Berkeley, and now if we can get some additional research from educational institutions, it ought to be able to be one of those pins pricking that balloon over the UFW's head that says, this is really a good deal. Because workers up in Washington State right now, even though they testified against the ag overtime exemption elimination, of course, the legislature up in Washington State went ahead and rolled over the farm workers' wishes and the farmers' wishes, and they got rid of the exemption. But they're asking the legislature to look at it again. New York State, the same thing. The farm workers up there are going to see exactly what's happening with regard to their take-home pay, with the exception that New York State has a tax credit that the grower can get back from the state of New York to help pay, to pay for the overtime that the grower may have to pay to that farm worker. Colorado would like to see that included down in Colorado as well, but you have to kind of wonder how long that's going to last with the state legislature that is shifting more towards the workers than it is towards the employers. But at the end of the day, we've got to have farmers and ranchers in the United States producing food and fiber for American citizens.
The second half of that question was what kind of time frame would we expect? And I think it'd be fair to say, obviously, it's a state-by-state issue. In Georgia, I would say we're fortunate.
I would agree with that, Chris. And my home state, of the great state of Wyoming, it'll be a long time before that legislature would ever move to go ahead and allow overtime elimination of the ag overtime exemption. But some of those legislatures that are more liberal in their thinking, and unless we can get enough academic evidence that shows what a bad deal this is for the farm workers, may continue to go ahead and make those pushes. But we'll see. We got to try to block them as best we can.
Yep. I would agree, and I think the takeaway there is depending on your state and depending on their politics, if it leans a little more left, I would think the immediate future would be the time frame where you would see that. Fortunately, here in states like Georgia, we may not be facing that pressure quite as fast, so if at all. So, any other questions for Michael? We've got one more presenter. Can we give Michael a round of applause? Michael, sorry you couldn't make it in person.
Me too. Hey, listen, you guys, have a good rest of your meeting.
All right, we appreciate you. Thanks for being with us.
And that's acknowledged to all of us, to be sure to use the microphone. Can you hear me in the back? Don't lose sight of the fact that Congress might eliminate the agricultural exemption under the Fair Labor Standards Act so that we don't get a choice in the Carolinas or Georgia, other parts of the world. Another thing I wanted to point out, can you get us to the slides? Okay. I don't have any really good news, and a lot of what I have to say, Michael Marsh already covered about the litigation, but I'll go through some of it. But meanwhile, I am going to talk, if he can get us on the slides, about the heat standards. They say the feds are coming out with official agricultural-related heat worker standards this season. But my son is presently defending a second-grade teacher on a murder charge because a child, middle schooler, died on a football field in August in a county south of Atlanta. She's a second-grade teacher. Her first day as an assistant coach on a middle school football team. She wasn't making enough money by staying after school to do this to make it worth her time to do it for the money. She'd been asked to do it. She was exposed to the school system's policy on heat injuries and when you ought not to have outdoor football practice. She did not know that there had been through the school system an email that day to the administrators and the official coaches and so forth saying, don't let the kids on the football field this afternoon. And regrettably, a child died. And did I tell you, that's a murder indictment by the district attorney in that county. And so my fear, as much, frankly, publicity as these sad things happen, if we have in the Southeast this season somebody die in the field or crawl off by himself and never come back, it's going to be a decision on the part of some district attorney whether or not everybody in sight, I'm not talking about just the supervisor, I'm talking about the landowner, the guy who had control of the field, everybody in sight is in jeopardy of having at least a manslaughter indictment and maybe worse. And you might say to yourself, look, I am a decent law-abiding person. I'd never let anything happen. And when I heard about this situation with the school's second grade teacher, who, by the way, was pregnant, not that that's a matter, and that she was indicted, I thought about its application to agriculture right away. And I remember as a child my father saying, you know what, I'd rather be accused of murder and tried in this county than a misdemeanor claim, because people know me and wouldn't expect me to do anything to hurt anybody. Well, it's a different world than it was, 50 years ago, 65, 70 years ago. And so do what you can. I can't provide these OSHA website materials in copy for everybody, but I appreciate your passing them around so that you can go online yourself and bring them. And if you don't do anything else in the way of preparing for a written plan that the OSHA regs are going to require, then take some of the materials out of the published materials that the Labor Department has given you, some Spanish as well as English guidelines, and have them in a file, because if Wage Hour or OSHA show up, and I'm saying law enforcement as well, if somebody dies, you want to have something in your file that says you've done what you could, and you can do some things. Well, before we go on, Beth promised that I would talk about the litigation. And those of you who are in the H-2A program now, how many people in the room are in the H-2A program? Okay, well, you know that you got the new regulations that came out in October 2022. And Michael Marsh explained that in the federal district court in Washington tried to enjoin the implementation of those new rules. The court refused. That case is still ongoing in the district court now in terms of the rule themselves. But as this lady here at the front pointed out, under the Chevron Supreme Court doctrine, the Labor Department gets a lot of deference to make its judgment about what is needed to protect U.S. workers. So far that's not been successful. Then in February this year, February 23, the Department of Labor issued new regulations on the so-called adverse effect wage rate. As Chris and Michael have pointed out, is supposedly designed to have a neutral effect to protect the wages of U.S. workers similarly employed. And I came to Fisher & Phillips in 1976. We had just won a case from the old Fifth Circuit, which covered from Texas through Florida, including Georgia, that said the Department of Labor has no right, no statutory authority to do anything other than try to set a wage rate that will have no effect on the employment terms and conditions, benefits, wages, and so forth of U.S. workers. And so I think, and I believe I caught Michael saying, that one of the things that we might do in litigation, but boy, we better, I say we, I come from a farming family. Frankly, my sister and I have sold every piece of land we own. And so, folks, it's up to you, I hope, for my family, my children, my grandchildren. But I think that the industry has to be really well funded. Glad you've got the relationship, or Michael's got the relationship with all those economists, because I don't know who those supposed legal U.S. workers are. Maybe there's enough multi-generation Americans in California still in agriculture to carry the weight. I don't see them, and I talk to a lot of different farmers in a lot of states from, here through the Northeast, through the Midwest. Deliberately I don't do California work because it's so different. And that brings up another point in terms of unifying the agricultural community. The state laws in California, Oregon, and Washington State are so onerous as compared to virtually anywhere else in the country that we really don't have a commonality. People can be sued under so-called private attorney general's law in California with big class actions. But anyway, I move on. So to try to deal with the February 23 regulations, 3 lawsuits have been filed, all of them seeking preliminary injunctions against those rules about a new adverse effect wage rate unless the work was encompassed within the original Big 6 job occupational codes that are surveyed by the U.S. Department of Agriculture. And in those rules, if you've got people who are over the road driving big trucks from, say, the sugar fields to the mill, the Department of Labor's position is those are to be paid like 52-week a year over-the-road, heavy-duty truck drivers. And I think we saw that Michael put up that wage rate in the state of Georgia, surveyed on a survey state by state, if there are enough workers to be surveyed, is over $25 an hour. There was, and based on comments by the Wage Hour Office of Federal Foreign Labor Certification Administrator Brian Pasternak at the conference that Georgia Fruit and Vegetable Association hosted in November, said basically if you've got somebody who is driving the workers from your particular farm from their housing back and forth between the housing and the farm and from field to field, that person is not like an airport shuttle driver who takes people from the parking lot or to the hotels. And so those people can still be within the traditional ag code for agricultural equipment operators, which would be the adverse effect wage rate now in the state of Georgia, $14.68 an hour. I think it's $15.81 in Virginia and the Carolinas, and up to $19.75 in California, with a whole lot of big rates for Nebraska, Minnesota, Michigan, other states that are in serious pain competing with the Canadian produce across the border. And so the problem, not just the problem, but a problem for me in this new way of looking at wage rates that must be paid unless basically you're in a packing house doing traditional packing house work, working in the field, riding a piece of equipment that's using for cultivation or planting and so forth, is that these rates would be paid to people who are working 52 weeks a year. And we're not talking about that kind of period of employment typically in the H-2A program, which by at least regulation today, says that can at most be a 10-month a year occupation. And so I don't think somebody who is driving a truck for Mr. Walmart or Target has the same job as a sugarcane hauler, which is one of the cases that's being litigated in the Western District of Louisiana. Because, you know, my memory is those mills start operating November maybe. They're going to have finished by March. Those people are going to go on to other things. That is not similar employment to the folks that are always working 52 weeks a year for Mr. Walmart. There is a similar suit on similar issues, again, involving these new wage rates for jobs that are not part of what they call the Big Six, the traditional ag jobs that just came down as a report from the magistrate judge on January the 5th. There is a 10-day period, and I'm sure it's underway, to appeal that to the federal district judge. And then there's another case that was filed in the Western District of North Carolina in Asheville that also resulted in an adverse ruling. It's not finalized yet, but basically agriculture zip. And there was another original lawsuit on the October 22 regs in the District of Columbia that is not finally resolved, but that also did not result in any relief for the growers. And so what I'm going to tell you, bless you, Bob, for all that you do and educating the political leaders and being part of the regulatory process. We need an Aflac duck or a Geico ginkgo. We need, as my granddaddy might have said, people to understand it doesn't come all come out of the grocery store. People have to understand that if they want to eat 3 meals a day, it's got to come from somewhere. And Bob, you had some data that I hadn't seen before that told me that what we've always relied on as our agricultural production helps support our overall trade, and although we're in deficit, has historically kept it from being worse. Someday, somebody's going to want some cold card, I hope cash, I hope U.S. dollars, I hope we're not talking somebody else's currency or, you know, having to provide it in gold. But we need an Aflac duck. We need people to understand that, as I do in the case of my children and grandchildren, I can't go out on the back 40. You know, one granddaddy did, both granddaddy, the reason I'm here today, frankly, is tobacco. But the other side of it is that as part of it, we did dairy farming, peach orchards, chickens, whatever would make $1 that they could figure out. And that mentality of knowing that the food is down the road, or if it's not out your kitchen door, it's on your farm, you know, 10 miles out of town. People don't understand that. So we need an Aflac duck that helps people understand that food security, just as much as petroleum fuel security, is ours. It's for us to make the American public want the elected representatives, congressmen and senators to think matters. On other litigation fronts, there was a decision last year involving Sun Valley Orchards, I think it is, in New Jersey. It's on appeal to the Third Circuit in Philadelphia now, where the ag employer challenged whether or not the claims against it could be decided just by an appointed employee of the U.S. Department of Labor and Administrative Law judge. And the court in New Jersey said, yes, the rights under the Migrant and Seasonal Agricultural Worker Protection Act, the H-2A program, and the Fair Labor Standards Act are all federal statutory rights. They're not like common law rights for which you would be entitled to a jury before an official court of law. It can be done by an administrative agency. That case is on appeal. It would take overturning a lot of precedent going back to the mid-'70s. Atlas Roofing is the first case I remember involving a decision by the Supreme Court saying that OSHA could have its administrative processes go up through an administrative law judge. But maybe the court now is more sensitive about some of these rights, as she pointed out on the Chevron case, of how much deference do you give a so-called expert agency. Another aspect of that case that bothers me, and I've seen it happen more in dealing with agency employees in the Labor Department recently, the fines for any kind of violation of any Department of Labor statute go up every year, January. I know the ones for OSHA violations, I think, go up to 116,000 plus for any kind of serious OSHA violations this year. I haven't seen the numbers for H-2A, MISPA, and Fair Labor Standards Act. MISPA will probably be over $2,500 a violation this year. H-2A crowding 2,000 for sure. In the Sun Valley case in New Jersey, the employer had failed to provide the housing, the kitchen facilities, and was, as it said in the job order, and charged the workers for providing the meals. There were something on the order of a couple of hundred employees, and the Department of Labor charged what were the fine penalty standards in 2015 when the fines were levied at $1,350 a person times the number of employees. It used to be that if you had somebody make a mistake, even though it affected 50 or 100 or 250 employees, that was one violation. You know, one penalty of, you call it $2,400 or $2,000. I've had this week somebody say to me, I am not authorized to accept a resolution of this case that doesn't involve an amount of money for each affected employee. Okay? Another case I want to tell you about is an Osagura Company case. I believe that was out of California. It was settled with the Department of Labor recently. Among the things that happened besides paying a fine, and that civil money penalty is what they call it, and back wages, was that the company had to agree on its nickel to pay an outside monitor who would make sure it was complying with MISPA, FLSA, H-2A, and reporting to the Labor Department. And that's something else I've seen more recently come up. Did Michael touch on the independent contractor regulations that came out this week on the 10th? Can't remember if he did or not. The so-called economic realities test of whether somebody is truly an independent contractor with an opportunity for profit or loss based on his own managerial skills came out this week. The verbiage that we're looking at, the economic realities between the so-called independent contractor and the supposed employer, has been in effect in this circuit and in the Fifth Circuit for a number of years. There was a case that was decided last year in the Western District of Texas involving the manager of an office for the Texas Farm Bureau. And he was held to be an employee of the Farm Bureau Federation, not an independent contractor. Among the factors that the court looked at were that he couldn't sell any insurance that wasn't Farm Bureau insurance, although he had the right ostensibly to recruit for and decide who he wanted as his staff. The Federation had yes or no authority over the decision. It's established what his pay rate would be and authority over what he paid other people in his office, even though he had to be licensed to sell insurance by the state of Texas. It said that your expertise in this is interesting but not a controlling factor. So what the Department of Labor did this week was say we're going to look at what the person's real opportunity for profit and loss is using his managerial skills. The relative amount of investment made by the supposed employee as compared to the alleged employer. One of the things that's interesting in these new regulations in the commentary is that we're not so interested in whether or not, if you will, in our contemplation, the contractor supplies his own buckets and ladders and various equipment to use in the field. We want to know what his entrepreneurial investment is in terms of better technology and that sort of thing. So that is a pretty significant change. The permanency of the relationship. You know, there are folks that have come to the same farm 15, 20 years. That is bespeaks in the eyes of the Labor Department a suggestion of an employment relationship. The control that the employer, that the alleged employer can have over the individual and over the individuals in the contractor's crew. Is it part of the integral part of the relationship or of the business? You know, that would be true in many occupations that use independent contractors. But they say it's a different thing if it's a expertise like a lawyer or an accountant as opposed to somebody who is involved in providing services associated with the very heart of the business. And whether or not the person has specialized skills, it says we're going to look at the totality of the circumstances and under those standards decide whether somebody is an employee. Now you think about this. There's a question then as to whether some of the contractors are going to be held to be employees or independent contractors. And if they are employees, if the contractor who brings your 30 or 50 people for 6 weeks or 6 months on your farm isn't going to be held to be an employee of your operation, so will all of the people he brings in. Okay, I'm going to refer you, and you'll have on this group a site for finding Micah Dickey, one of our colleagues who does OSHA work particularly. Look at the new OSHA record-keeping electronic filing requirements. Farming in fruits and vegetables, livestock have been held now to be particularly hazardous duties. And if you look at Micah's article from January 11, you'll see a summary of the new record-keeping rules, and he can link you into how to determine whether you have the requisite 100 or more people that you would have to report on for any kind of injury, as well as keeping the log that you would have to make an affirmative report on. I want to point out to you that in the last year or so, I've had not more discrimination cases involving agriculture, but it's apparent that those same people who are catching the workers on the way to and from the consulate to get their H-2A visas are talking to them about every aspect of law, you know, hours worked, what's really to be counted as hours worked for record keeping and pay purposes, discrimination. Don't let it happen on your farm that somebody slings homophobic slurs, jokes that you saw in, The Office years ago with Ed Helms. You can see it on TV. Don't let it happen on your farm, because it'll be your pocketbook that is subject to the cost of the litigation and potentially back pay, punitive damages, and other consequences. In fact, I just saw a case in which even in that the EEOC required monitoring of the conduct on an operation. It wasn't a farm, but as I told you, that H-2A case. Sexual harassment. Make sure that your supervisors, people who are in the field, if they hear something happened in the packing house, or somebody is pressing somebody for so-called dates, don't pray it's going to go away, because a percentage of those things are not going to go away. It'll explode in your face. I'm not going to call any kind of your customers by name, but it won't surprise you that if it hits the newspaper, and these are salacious, ugly things when they hit the newspaper and the TV, your customer's going to be somewhere else. And another aspect of this that is true, whether we're talking H-2A, Fair Labor Standards Act, is don't let somebody retaliate because somebody brings something to your attention. And even if somebody brings something to your attention and says, I'm not sure if this is so, but it could be so-and-so is hitting on such and such, and you got to know what the nomenclature is to read between the lines of what people are saying and not saying, and it turns out not to be true. The fact that you had this early warning system to let you look into a potential problem and find that there isn't one, in my world, I say thank you. I appreciate you bringing that to my attention. We've investigated, it's not so. Okay, we've got a little bit more time, and I wanted to go back and talk to you a little bit about the heat stress, because I think this is such a big issue and I think it's going to hit about the time things really get, if you will, hot in Georgia, South Carolina, and so forth. All right, I'll remind you that this is an open forum. Our discussions are not legal advice. It's not confidential. I want to invite you to go to our website, fisherphillips.com. Up in the upper right, I think, is where the news and alerts are. You can sign up and never talk to one of us lawyers and just get the alerts to your email inbox, or go look at what you're interested in, or it's a pretty good search engine on issues. You can pull up materials. I put in here for Chris and me to remember, Travis Vance, who is one of our chairs of our OSHA practice group, who does a lot of ag OSHA work, has said he'll do an hour-long seminar at no charge to people who sign up. We just got to get it scheduled and get him on the books to do it. All right, so one of the things I might say to you is that this is just a very brief overview of slides on my concerns about heat standards. You're supposed to have, under the regs that are going to be published, a written plan. If you can't do anything else, go to FedEx and print out the Department of Labor booklet on what the heat training standards ought to be, what it ought to include. Put it in a file. Put your farm name on it. We learned from the OSHA materials that acclimatizing new workers to the heat is important as a way to minimize the likelihood of somebody becoming seriously ill. Figure out how you're going to get somebody cooled down and first aid if something bad happens. You know, in many states in this part of the world, from the southeast down, if you wait for the EMTs or ambulance to come, somebody could literally be dead. So you got to figure out how you're going to cool somebody down in the field or where he or she is while you're getting the 911 taken care of. And think about it in advance. And you might say, well, I got a contractor who's responsible for doing everything on the farm related to employees planting and picking. Well, OSHA already says if you've got somebody who is the site controlling employer or in a position to be correcting, that entity also can be cited for the violation. And I also already said, not even thinking about OSHA per se, but considering that there could be criminal liability plus your ability to sleep at night if you didn't make sure there was sufficient ice and a way to keep somebody cool or cool somebody down. One of the worst things that you can possibly hear is the boss man said, nobody takes a break except when we call a break. Nobody better step out of his row or he's going to go home, not just for the day, but for whatever. You don't want to hear that from the witness stand, whether it's an OSHA enforcement proceeding or a criminal proceeding because somebody got sick or had worse or had very serious injury. Make sure your own supervisors know that they got to pay attention about the heat stress issues, and make sure that your contractors, if you're using contractors, that they are conversant in what the heat standards are. So you can go to these sites on the OSHA website and find a lot of useful work. I mean, I got to tell you, the first time I read the notion that if the heat humidity index is 95 or so, you should have people work no more than 45 minutes and have them rest every 15 minutes. I mean, that on top of your current hourly rates, you can't do it, can you? And so I think you got to think about other things. So as I said, you have a legal duty, even without the formal promulgation of these regulations, to provide a safe, reasonably safe workplace for employees, free of recognized hazards. And in today's world, heat is going to be, I fear, a recognized hazard. The people who are most vulnerable are new, temporary workers, according to the Labor Department. Now, I'm thinking that if somebody has come in February or March or maybe even April to start in the clearing of the fields or the original planting, by the time the heat humidity indexes get really hot, that person is going to be fairly well acclimatized because he or she will have been working gradually. But as we're more and more concerned on making sure about every dollar does its job, and maybe your harvesting period starts June 15, July 1, and you try to bring in your workers or more workers as close to those dates as possible. When that guy gets off the bus, if he's been watching the equivalent of The Price is Right at his home in Mexico until the day before he got on the bus. He is no more acclimatized to the heat from Virginia south than I am, right? You got to figure out how you're going to manage that. If I were still in farming, I would maybe give some thought to whether I brought in more people earlier in the season, knowing that I had to deal with the fact that, as Bob and Michael point out, when people come here to work, my experience is they come to work. 60 hours a week is no surprise at all, and many of them will volunteer for more, right? And they want all that opportunity, or maybe they'd even leave you and go somewhere else that's letting them work more. Somehow you got to find a balance. You got to do some education, some training of your workforce to let them know we're concerned. We don't want to send you home in a box. We want you to be healthy and keep yourself healthy. The OSHA recommends that based on the level of physical activity, and I don't know anybody working on a farm in a field who is not in that heavy-duty category, what the wet bulb globe temperature readings are, you got to figure out how you're going to address it. Among the things, as I said, you want to make sure you've done is do some teaching of your workforce. If you feel lightheaded, and we'll come to some symptoms in a minute, or have some of those symptoms that suggest you're overheated, that your body is rebelling, don't let people slink away and try to get under some shade somewhere by themselves. Make sure that that your supervision is watching them, and there's no reason not to tell other employees. Watch the guy in the next row. If he's faltering or seems to be having trouble, let somebody know. The combination of factors, even when it's not so terribly hot, includes, of course, the humidity, as everybody in the South knows. What kind of clothing somebody is wearing, whether the person is obese or fit. You saw in the Department of Labor statistics, 50% of the deaths occur on the first day, 70% in the first week. I mean, it seems to me that if you can, at the very least, you may want to make sure that you've got lighter work when people first arrive, or when the individuals first arrive, if they come in to substitute for somebody who absconded. The Amazon worksite has a jillion wet bulb globe temperature devices at various prices. There are downloadable calculators for your daily planning. Told you again that there are individual factors related to your health status of the workers that affect the propensity to be overheated, to get into trouble from the heat. But remember this, all these laws work together. It's not like it's either or. It's that you got to comply with everything. And the Americans with Disabilities Act forbids you even from inquiring about somebody having certain kinds of a health condition that might interfere with their ability to work. And even if you found out through some means that somebody might have a propensity, say high blood pressure or diabetes, you have an affirmative obligation under that law to accommodate the person's condition. And so just don't think you can look at Mr. High blood pressure, walking diabetes, obese guy, and not hire him, and come out clean on the OSHA. All right. So here's a listing of some of the symptoms. Make sure that you can cover this. Maybe get this translated. Probably, if we look at that OSHA site document, we could find, uh-oh. What have I done? I think maybe I have run out of time. Well, okay, that'd be great if I could make the slides continue. But anyway, they're frozen for the moment. I'll tell you what else is in there, and I think they're making them available to you to the extent that they're useful to you. One of the things I did want to get to, okay, great, is how do you cool somebody down? Those blue liquid frozen ice packs, that's a practical suggestion. Make sure those things are in the field in the event somebody gets into trouble. Put up some of those pop-up tents, mandatory now in California for certain kinds of shade, but those things are not terribly expensive. Find a quick way to cool somebody down. I looked at the little child wading pool that my grandchildren had. I wondered if I still had a farm, would I put that in the back of a pickup so that if somebody needed to be cooled down quick, I could have them sit in that thing and put ice packs under their arms and cold towels on their bodies and cold water? Maybe I would. I'd certainly know more than I know today about what you do about the heat problem. Make sure, for goodness sake, make sure that there is the suitably cool drinking water always available, 50 to 60 degrees. I can't tell you how many times OSHA and Wage Hour that looks at these issues has showed up on the supposed very day that the ice machine was broken, or that's why we ran out of water and ice. Figure out what you do in advance of getting EMT or emergency service. What do you do? I said in November, and I haven't done it, but it's on my personal list of things to do. You can do emergency EMT type first responder classes. It's not an expensive thing, but I'm gonna do it for myself because the Red Cross provides it. Probably there's somebody somewhere in your county to do it. All right, I'm saying, as you file your job orders for this year, particularly to cover the hot summer jobs, I would put in my job order that when daylight permits, we might start earlier than whatever is your normal starting time, that you have to put on your 790. Maybe it's 7 o'clock. Maybe we start at 6. Maybe we start at 5:30 to permit work to be largely completed before noon or before 2 o'clock. Consider split shifts. In the Georgia session, we said, well, doesn't that mean you got issues about hours of work? Well, yes. If you have people work from, say, 5:30 or 6 in the morning until noon, and then you completely relieve them of all duty and take them back to their house so that they can effectively use the time until, say, 4:30 or 5 or 6 o'clock for their own use. I think the law still lets you have that. But if you don't have the possibility of altering hours in your job order, then you're stuck with what's in your job order. Make sure everybody understands we're not having to take somebody to the hospital out of this field. But if somebody gets sick and needs it, that's what we're doing. We're not going to cover it up. We're going to make sure, what I'm telling you, we're going to make sure nobody dies on this farm. Would be my rule if I still had one. All right, this is really a quick summary. Chris, thank you so much for the invitation. I hope this is useful. If you all like, Chris, if you want me to get Travis enlisted for something more in depth, he's glad to do it toward the end of February. And so thank you all. It's always a pleasure for me to be with you, and thank you.